Awesome. Hi, Amir. How are you? Good to see you.
Hi, how are you? And well, thanks for having me.
You're most welcome. And I'm super excited today to introduce Amir to our audience on this live podcast that we are doing. And the topic today is quite exciting and something which is, I think, ignored by many, not because they want to, it's just because some are either ignorant or people just put it off, on the back burner. So, wills and estate, that's what we are talking today. And why every person who's thinking of building wealth, why this is something that is absolutely required for you to consider, whilst we are all here and alive. So today, Amir has been invited to help us sort of, get into the details of the questions that people have around the wills and estate, and will take us through that. But so before we go ahead, let's welcome Amir and at the same time get some background from Amir as well. So Amir, welcome to the show, and
Thank you.
let's start with your background and what you do and your services you provide in your business. Thank you.
Sure. So, first of all, again, thank you very much for having me. It's very exciting to be appearing on your show. So, a bit of background about myself. I've been in the legal industry for almost 20 years. Started off working as a law clerk, as a paralegal for 5 years, and I then graduated and uh, signed up and became a solicitor back in 2010. So I've been a legal practitioner for 15 years. Um, I worked in I worked in two boutique firms from 2010 till 2019, and then I co-founded my current firm, Zari Lawyers, which is part of the Zari Group. So we've got different arms to our business. Legal, which I lead, accounting, advisory, and IT. We are based in Melbourne and Sydney. We've got an office in Docklands, and we've got two offices in Sydney, CBD and Bankstown. Services we provide in the firm, we're a general law practice. Um, we do mainly commercial law, corporate, business, property, wills and estates, employment, and we also do some family and criminal matters. So that's it, I guess. Yeah.
Wow, that's awesome. I am not sure what invoice you're going to send me after this call because you are a busy lawyer and I've got lawyer's time for about an hour. I'm not sure how much I have to pay to get you going on this one.
No, no, it's free for you. It's actually exciting for me to be appearing today and hopefully shed some light on a very very important and ignored topic. So yeah, I'm looking forward. Thank you again for having me.
Awesome. Thank you, Amir. So we'll get started without spending a minute talking anything else. So without any further ado. Now, Amir, one thing is that, of course, wills and estate, which is a lot of people think they can go into the post office and get a will made. How
Yeah.
good is that? And is that something that's recommended?
Look, as a legal practitioner, I would say no. I think there's a lot that goes into wills, into estate planning, that probably someone general public wouldn't know, and they are quite honestly not expected to know. So I think, look, if someone has a very limited estate, one property with a spouse that they own it as a joint tenancy and no other assets, then maybe it could be an option. But I think most cases, it's highly recommended to actually do the proper planning and go to as a specialist, someone that understands the law, someone that would shed light on a lot of areas that this individual haven't probably thought about, just to make sure that they have the best, they leave their family with the best plan moving forward after they pass away.
Right. So let's put it this way. Let's say I have no assets at all, and I'm a renter, for example, right? I might have some, um, maybe I've got a car and a bit of a bank balance and so forth, but I've got no property as such, as an example. is that still recommended that I should do a will?
I think as a base, yes, because that car that you own is an asset. Your savings is an asset. Your personal belongings, if you own some watches or whatnot, that's in itself is an asset that you probably want to leave for someone to take. So it doesn't have to be real property, it doesn't have to be real estate for someone to decide and to do a will. People at the moment, for the last few years, there's a lot of online currencies and so on, and shares, and so there's so many different ways people invest their money that they probably should regulate how they want it to be distributed through a will. That's number one, and I guess number two, which is also very very important, is the fact that, and we've had this on many occasions where we have clients coming in and saying, I want to do a will for the future, meaning that we create a will and which states that all my future real estate, that's how I want it to be distributed. So even if you don't have the property currently, the will can cover that future, say, possibility of you owning that property.
So I think there's a basic question: what is a will, right?
What is a will? Well, a will is a document that dictates and regulates how you want to leave your assets after your death, after you pass. There's many factors to consider when making a will, and if I may just break it down, first thing to consider when you're making a will is the executor. The executor is, or a trustee, is a person that you will entrust with basically following your instructions in the will and making sure that your assets are distributed the way you intended it to be. The executor can be a family member, can be your spouse, can be your brother, your sister, your son, and you can also have co-executors. So a lot of the time we will have a person that is making a will, and they have 3 or 4 children, and they make 2 of them as co-executors. And we always encourage that, to be quite frank, because it avoids a conflict when you leave all the decisions in the hand of one person. That could create unnecessary disputes between the siblings. So it's good to have more than one in that instance. And so that's the executor. And also to mention, the executor doesn't have to be a relative. It could be a professional. So it could be the legal practitioner. And I guess what comes with that is that to perform the role of the executor, that professional person will probably be charging the estate. And also, even if you appoint one of the children as an executor or a relative as an executor, they do have the right of asking for compensation for their time. But what's usually, because they are also a beneficiary, a lot of the time that doesn't get brought up. So that's number one, the executor. Who you gonna trust with making sure that the affairs are executed to the way you want it. And then the beneficiaries, they are the people that will benefit from your estate, and then in the will state how you want your assets to be distributed. So it will say, if, for example, people will have a certain property that goes to a certain child, or a gift, a personal gift to another child. The role of the executor, like we said, is to make sure that that it's complied, that all your wishes are complied with. So the executor, the beneficiaries, and how you want it to be distributed. There's obviously other topics that we will talk about that are a bit more problematic, but as a base, that's what's needed when making.
That's awesome. The next question really is what happens if I don't have a will and I die?
Okay. If someone passes away without a will, then basically it's the way your assets will be distributed will be in accordance with the inheritance law in the state where you pass away, where the assets are. So in it just creates a lot of unnecessary costs as well, because an administrator will have to be appointed to carry the affairs of the state and make sure that it's distributed. Um, it's also could be an issue, because if someone passes with an estate that has a lot of consists of a lot of properties, for example, they may intend to leave a certain property or a certain gift for one of their children, or for a brother, or for a sister. If they do pass away without a will, there's no guarantee that it will be distributed the way they want it, and it also creates a lot of issues. Sometimes we see it between the children, for example, or siblings, where they are arguing over who should take what.
Okay. So I guess the thing is that are you saying that the benefits of my estate can still go to the people involved as beneficiaries, let's say my immediate family, but the actual execution of that is now in the hands of the legal practitioner rather than actually my family to make a decision? Is that what it is?
So your spouse, for example, can apply to be the administrator. But I guess what I'm trying to say is that um, it just the process will be longer and more costly for your
Right.
family. This is money that they could be using, to
Right.
yeah to
So, so it's more streamlined if I have a will up front, essentially, and then the administrator is just going to follow the plan based on the will, right, and then distribute assets
well,
according to that.
sorry. So what he's saying is the administrator will follow the basically it's just in accordance with the inheritance, with the law of inheritance in the state. If there's no will,
Yeah,
um, if there's no will,
if there's
um,
no will. Okay.
if there's yeah.
Yeah. So let's say I've got movable property and immovable property as part of my will. So how does immovable property transact, after I actually die to my beneficiaries?
In the absence of a will.
Yeah.
Okay, so for example, if the thing is with a lot of those, we can probably create a scenario and go through it. It's probably going to be more beneficial. So give me an example, and let's
Yeah.
let's
Yeah. So let's say I'm married. I've got three children, and then of course the children, one of them might be already above 18, the other one might be minor at this stage, and I've got, let's say, three properties, some shares, and maybe cash are worth $100,000, for example, right? And shares are worth another $200,000, for example, and I've got a bit of superannuation as well, which might be another $200,000. So there's $200,000 worth of superannuation, $200,000 worth of shares, 100,000 in cash, and I've got four properties and three children, two minor, one adult, and a wife.
yeah. Okay. So first, before we discuss that scenario, let's just define um, what's called non-estate assets. Non-estate assets, and that's probably a lot of people don't know that. Super is not part of your will.
Right. Okay.
Superannuation is not part of your will. Your life insurance, if you do have one, is not part of your will. So what we always say, make sure that you're on top of your super policy, of your life insurance policy. If you have one, for example, make sure that your beneficiaries is who you want this money to go to. A lot of people fail to do that. Unfortunately, they create their first super um, account when they're 18 or 16, when they start working, and they probably had someone else as a beneficiary. And that's why we always say it's always good to go back and make sure that the beneficiaries are who you want at this point of time. So just as a point, super life insurance, and it's not an estate asset, so it has to be dealt with uh, parallel to your will and to your estate. And in this scenario, we're talking about someone that just left four properties. Now, if the properties are by if the properties are held between him and his spouse as joint tenants, for example, then the rule of survivorship will apply, which means that after he does pass away, the properties will automatically go to the spouse. Now, for all those other assets, shares and savings, if it's a joint account between him and his partner, then again it will go to her. There will be just an internal process with the bank, and then the shares and the other assets. This is when the spouse will apply for what's called letters of administration, become an administrator, and it's just a process of getting there where everything is transferred under her name, and then she will deal with it, becomes her assets. Then how she leaves it for her children is when we unfortunately see the spouse coming to make a will straight away, because they've gone through this process.
Right. So that actually brings me to another question. So, for example, let's just say, the wife takes over the administration, and then she's in the power to make this work. But a lot of people, like especially women, are unaware of a lot of financial aspect of this whole wealth. That is probably being created. They probably don't know which assets have been purchased, where they are. It might not be even in their names. So, like for example, some people like myself, that I'm running a business as well. At the same time, business is also an asset for me, right? As such. So, but if my wife is not involved in daily aspects of my business, and at the same time, I might have assets that she's not aware of. How does that work when your person who's applying for administrator is not even aware of what does the state really include, and what's there in it?
It's definitely a problem, and the more involved a person is in business and is part of different structures and is a beneficiary of certain trusts, and this is when it becomes very complicated. This is when it is a must to make sure that your partner is aware of all of your personal affairs, because, like you said, it becomes very, very problematic. There's ways to search for a person's name, search for to see if they own property. There's different softwares that would help. If you go to a lawyer or an accountant, they can help you try and look and trace assets that belong to the deceased. But like you said, if it's part of a complex structure where there's a corporate trustee and then there's different kind of shareholding and so on, then it becomes almost very, very difficult for the partner to try and trace those assets. And it's even worse when someone leaves, for example, minors and so on, and that's a different topic on its own. How to make sure that you've got enough measures in your will for your minor kids to be looked after.
Right. So let's say we do have a will, and the will. I believe there's no age group for the will to be set up, right? Or do you have to be a? Do you have to be?
It is. You have to look. You can do it if you're under 18, but in certain circumstances, court might accept, might agree to the person making it if they're under 18. But 18 is the legal age for the will.
So let's say you're 18 and you're 18 plus, and you have a will in place. You might not have any assets at the beginning of that age group. Let's say at 19, I set up a will. How often should I be updating my will?
What we always recommend is to update the will when there's a major life event. So marriage, children, divorce. Those are the main triggers for you to say, okay, well, I probably should need to look at my will and make sure that it's all still in according to my wishes, my current wishes. Also, if you, like you mentioned, if you entering into uh, a venture, a business venture of some sort, and you're aware of your structure, then it's probably a good idea to mention that in the will. And there's two aspects to it. So you've got um, your your will that where you will mention this asset and how you want it to be distributed, but you also have the structuring part, which is a different topic for another day, which is the structuring part of your business. Um, how you involve your family and make sure that they are part of your share in that venture.
Right. Okay. Understandable. So I think it's a matter of basically looking at major milestones, but also let's say if I'm expanding my business or I'm expanding my wealth through buying multiple properties, is it recommended that after every settlement I should be updating my will, or is that just automatically considered that because it's in our names that will be taken
Yeah.
care of?
Okay. So this is a topic as well that we got asked this a lot. In a perfect world, the answer is yes. However, there are depends how you've set up your will. So for some people will say, look, I want everything to go to my partner, my spouse, and then um, after that it just goes equally between my children and that's it, and vice versa. That's standard and it's majority. Now, we also deal with probably more sophisticated investors and individuals that with the estate, the value of the estate is much higher, and there's constant change. And some clients would like they dictate which property goes to who, and
Right.
we list the addresses and we list how they want it to be distributed, each project, each. And in that case, then the answer is yes.
Right.
But if it's one, two properties and you've got your principal place of residence and you've got one investment property that's owned by the husband and the wife or the couple, and then and your will states that everything goes to the partner and vice versa, then you probably don't have to do it straight away. Is recommended, but it's still the initial will give the same effect. But like I said, it is a personal preference. But at a minimum, you should have a will that yeah that has, it's a baseline, and then if, like I said, moving forward depends on how things will go. We recommend definitely looking at it every time there's a major change in your life.
Sure. So the question's also on the screen. Do I need a will if my assets are in a trust?
As part of the discretionary trust, it's probably not regulated. It is not regulated by the will. The trust will regulate itself. But I think this goes back to the point that we were talking about a few minutes ago about involving your family, involving your partner, and making sure that they know what's happening in your world, in your business world. So this trust could be. So what we usually do, for example, as a firm, we send our clients a will questioning that would include all the assets. And when I say all the assets, I'm talking about also the non-estate assets. It's usually kept with us, because if we're keeping the original will, obviously the family will come to us after the person passes. So we then bring this up to be able to assist the family. So that's one way to look at it. But the answer to this question is no. But make sure that it is your family are aware of that trust. If they are beneficiaries, if that's how you say, if you're talking about a family trust and your spouse and your children are beneficiaries, then no, you don't need to mention it in your will. But whether you need a will, that's a different question. Just so we're clear.
Right, right. I understand. So let's just say, an event does happen like that where there is a will in place, and the spouse is also aware of everything that the family owns, and there is this property that we're talking about in trust, and this property probably in the name's personal name because you've got your family home probably in that name as well. And of course, there's loans on these properties that we're talking about. So um, is this a responsibility of the person or the administrator who's taking that on to sell those properties if you have to, or is it actually going to be someone legally involved who will help in selling these properties so you can free up the cash if that is required to do?
Okay. This is it's a case by case basis, but there's a certain order. So there's a certain order that we can't escape. So obviously, when an executor is given that responsibility, and they have an obligation to make sure that the estate has liabilities, um, and the the assets are not distributed, or the benefits are not distributed to the beneficiaries, or the gifts. This is the second step. First step is to make sure that the liability of the estate is dealt with, whether it's outstanding tax, whether it's outstanding loans or loan repayments on cars, and so on. So the estate, there's a, and that's part of what, when you make an application for a probate, or there has to be a list of assets and list of liabilities related to the estate of the deceased person. And then based on that, it needs to be managed properly, making sure that, so it could be the kids, they will get together and say, look, we don't want to sell. Or the partner is saying, no, I want to sell. I don't want this pressure of investment properties. I just want to sell, cash out, and pay off my mortgage and maybe just have some savings. So it's hard to set a general rule to what should happen. Depends on the estate. But yes, I guess the main rule is you get rid of the liabilities. You make sure it's all attended to, and then we see how the residue will be distributed.
Okay, awesome. So, in terms of the actual fees of executing that will after the person dies, how does that work? I mean, is that the cost? Is it a fixed cost, or is it a percentage, or how long does that process take as well for things to work out?
Okay, so after the person passes, so we in the presence of a will, then we apply for probate. Obviously, there's usually a scale of fees of how it depends on the work involved. Really, it's hard to say, look, there's a set flat fee, but I'll talk about my firm because that's how we like to operate. We do set, we assess the situation, and we give a fixed fee for applying for the probate. Now, what happens after that, it depends on the executor. So once the probate is granted, we've had matters in the past where where it was more complicated, and the executor did seek our assistance in dealing with all the affairs of the estate. Obviously, the beneficiaries were involved, and they accepted our involvement. Where in other matters, we applied for the probate was granted, and then between the executor and the beneficiaries, they've sorted everything out. So to answer your question, is it a long process to get the probate granted? If it's a simple estate, there's no requisitions from the Supreme Court, we could be talking about it's hard to put a time, to be honest, because it depends on the timing. I don't wanna commit to a time. As a lawyer, we never commit to it, but I
Yeah,
would
because
say a month to two is probably a reasonable amount to
yeah,
commit.
because why I'm asked the question on time frame is because what you're saying is that uh, whilst we are planning all these wills and so forth, there should be enough funds as well in the bank somewhere that the other parties have access to pay off all the other outgoings or whatever is going on before defaulting on those, because it'll take about a month and a half or two before you can even act on this estate and
Correct.
clear those liabilities that you're talking about, right? For
Correct. We
example.
always look in a perfect world. We always advise people to have a separate, yeah, an amount for the funeral and so on, an amount to keep the family going for this couple of months, or ideally a bit more, because like you said, we were talking about an amount of time to be able to deal with the estate, let alone dispose of the assets or get access to the bank accounts. Because once the estate is granted, the executor then need to make individual applications to, um, for example, to financial institutions that hold the savings, for example, or and so on. Unfortunately, with life pressures, and it's not usually the case, not always the case, I should say, where people are able to leave that buffer for the family. Um, yeah, so we've seen both sides. Obviously, it will make the life of your loved ones so much easier, especially that they will be grieving, and it's a very emotional time if they have the amount that they can use for the first 1 or 2 months.
Right. So the next question is, what do you charge to create a will?
Say that again. Sorry, I missed that.
What do you charge to create a will?
What do we charge the creator? Well, okay. So I guess I'll give you the answer, but just a small disclaimer as well, that wills um, can be a straightforward document, like we've mentioned before, and they
Yeah.
can also be very complicated. So we charge $600 plus GST for the preparation of a will. If the work involved is out of the ordinary, and it will involve much more time, then we would charge an hourly rate, but this would be communicated to the client very early on before any engagement, so they can then make their mind. And also, if it's a couple and they are doing a will, we do give discounts. So it's I guess the amount that people pay to get a will prepared, I would say, is minimal in comparison to the how much time and stress you will save for your family later on.
Yeah, of course. And I'm sure that when the wills are being created, people really don't have much idea of what to do, and you will guide them of steps. Like you said,
One
there's a lot
hundred percent. One
to
hundred
really
percent.
to know
Yeah.
exactly what they own, what is it that they have, the complexities that's involved with it. Because a lot of the questions that should actually, there's a lot of planning part of it that should go into it, that people should be aware of what you're really thinking and how you're thinking. Remind you, I mean, people haven't done this before. So, are you actually prompting people? What are the questions to really consider when they're thinking of
Uh,
planning
Yes.
as well?
So we have an initial email that goes out to all the clients with that pretty much get them to think about what is an asset, what can I include, what I can't include. We have a will questionnaire where they have to answer, so it's kind of forces them to remember, that what do they actually own, what can be part of the estate. And then we guide them. Obviously, every situation is different, but our aim with wills and estates is when we prepare a will, we look at the family dynamics as a whole as well. That's very important. That determines how a will should be granted. We speak to the person that's making the will about who can be the executor. Is there any issues within the family? How do we manage this? And to make sure that they are comfortable and aware of everything that's in the will. So all non-English speaking clients will have to get we make sure that there's a NATI accredited interpreter that we use to read the will word by word to the client, make sure that they understand, sign off on it. So it is an emotional process. We are aware of that. We understand also that people don't have that knowledge, which is very normal and not expected. So it is something that we value as a firm. When someone comes to us at this for this kind of task, they put all the trust in us. They trust us with the affair of their personal affairs and their family's future affairs, and we take this seriously.
Yeah, and I'm sure, like, because no one's done this before, like, there's first time for everything that people get into, and this can be quite overwhelming process as well, especially depending on the size of assets and the complexities involved in the family structure that people have. Because I imagine that people who are remarried, divorced, remarried, they've got few children from other relationships as well. It can get a little complicated, isn't it?
It can get complicated. We are obviously here talking about the basic principles, but it can get very complicated. Multiple marriages. For example, we have scenarios where the person making the will wants to exclude one of their kids, for example, from their estate, and even if you can do it through closing the will, you can do it through a estate deck. Doesn't stop, and we say that to the person making the will, doesn't stop your child that you've excluded from making a claim in the future after you pass. So there's a lot of elements to consider. Overseas assets is another one that we prompt people to think about. Living in Australia, we all come from different backgrounds, come from different parts of the world. Some of us have, or their families have had assets overseas. We got to look at it at which country, which jurisdiction, how can we incorporate it into your will? Can we actually do that? If not, then they must have a will in that particular country, and we make sure it's mentioned. So there's a lot of factors to consider.
Oh my God, I haven't even thought about the overseas part of it. And you're right, because there are so many people who have assets. Maybe their parents are, they own the assets right now, but down the line, they're thinking about that as well from their end. And if something happens over here, then they're going to inherit all of that as well. So that obviously needs to be part of that whole discussion and taking that into consideration as well, isn't it?
I think it's very, very important. It's part that's back to my point about how we prompt people to think about. We ask this question, and you'd be surprised how many times we've had clients say, "Oh, actually, I've got this land, I've got this house, I've got," and we make sure it's dealt with the proper way.
Wow. So in your services, is this more like a one-time thing, or is there ongoing fees, maintenance, whatever we need to do, or is that, how does that work?
It's a fixed fee for preparing the will. It's a fixed fee for preparing the will. The will, then you've got the option of keeping the original. We have our safe, we have our wills register. So we give this option to the clients as well. Most of the clients will end up leaving the original will with us as a firm, and we, like I said, it's there's a physical copy and there's a copy on the server on our legal software. So it's saved in multiple places. But this is when, if the person, and again we recommend, obviously this is at least, I wouldn't say whether it's the executor or the beneficiary, there has to be someone close to that person that know where their will is. That's very, very important.
Okay, awesome. There is a basic question that's been asked. What does probate mean?
Okay, probate basically means it's a process to verify a will. If you put it in a very simple terms, it's a process whereby the court, Supreme Court, will look at the will, accept that it has been executed correctly, and grant the executor then that power, or the administrator the power to deal with the estate. The executor and the king.
So basically, it's just a legal term for the process with Supreme Court. That's what you're talking about, right?
It's you can't dispose of the assets without the Supreme Court saying yes, it's a valid will. Yes, you're the executor, and you can now deal with distributing the estate or dealing with the affairs of the estate.
Okay. There's another technical question that's come up, and that is, what is the difference between administrator and executor?
Okay, so the executor. So the executor of the will is the person that gets appointed, like we've explained, as the person that's like a trustee, call it trustee, someone that been entrusted with dealing with the affairs of the will. Administrator can happen when a person would pass away without a will, so they will apply for what's called letters of administration versus probate. So probate is when you have a will, you make a probate application. You don't have a will, you make a letters of administration application. Then you get an administrator appointed to deal with a similar role to the executor, but different. Or it can happen if the executor pass away. So if you have an executor, it's another point that I probably forgot to mention. We always recommend having more than one executor if you can. So you can have co-executors, you can have two people acting together with different roles, or you can have a substitute executor. You can have a main executor, and you say if they're not around at the time of my passing, then I want this other person to be the executor.
Okay. Yeah. Right. But in that scenario, being co-executors, when actually the will has to be executed, doesn't that create a lot of confusion between the two?
So the will, the way the will is executed, you've got the person making the will. You need to have two witnesses. Usually, we don't want the executors, we don't want the beneficiary. We want two independent witnesses over the age of 18 that can witness the signature. They don't have to be together, so they don't have to sign before the two witnesses.
Yeah.
That's the execution of the will part. But then the confusion is, if we have co-executors, most of the cases they will be also beneficiaries, and they will work together to make sure that the estate it's in their best interest, put it that way, to get the affairs sorted. Because remember that the executor, it's a responsibility. The beneficiaries are the ones that would benefit from the estate. With the executor, it's a responsibility. So there could be disagreements, obviously, between co-executors. Don't get me wrong, and it happens all the time. But should we sell? Should we keep? Should we buy? But there's mechanisms to deal with that's when it gets to be more complicated.
Yeah, but executor can also be a beneficiary, right? Essentially.
Of course.
Right?
Yes. Actually, most of the time, that's the case.
Yes, so that could also be a conflict of interest.
It is not a conflict of interest. It's only, the beneficiaries have the right to raise a concern and make a claim and say the executor is not acting in the best interest of the beneficiaries. As a general rule, again, that's why we go back to the main point. If you're going to appoint an executor, you have to trust them. You have to trust them. They have to be the most trustworthy one of the person in your life, really.
And that executor can be anyone, even outside the family as well, right?
Doesn't have to be a family member. Doesn't have to be, and a lot of people do that. They say, look, I trust my lawyer, my accountant, my advisor. they could charge for it. So a lot of people, we give that disclaimer as well to clients. If you're going to get a professional to do it, they will charge for their time.
Yeah.
Could it be a percentage? So some people say yes. I don't want any of my kids to be an executive. I just want this person to be in charge of the affairs. They stay as beneficiaries, and I'm giving everything. I'm leaving everything to them. But I don't. I want to avoid the possibility of them having arguments, basically, of how to deal with this.
Right. It actually just makes so much sense in what you're saying because, like, what, just to people who have just joined, I think in summary, we are really saying that doing wills is not a discretionary or a choice. It is a must. And people even from age group of 18 plus should consider actually doing a will, even if you just own a car and no assets. It is absolutely well worth the effort doing it. It takes much shorter time and it is more streamlined process uh, as once you have a will in place, and you should keep updating the wills at major milestones of your life, whether it's wealth building or whether it is to do with events in your life that you talked about. And I also take away that, of course, the cost of getting this done professionally with like yourself versus actually, picking up something from the post office can have a significant difference in the outcome of how that legal procedure will run. Is that right?
I think you've summed it up perfectly.
Right. And I think also it is quite important that people don't take this lightly, especially when they're looking at building things. Like you said, superannuation is completely outside the wills that we're talking about, and also the assets in their trust. So it's quite important to also factor in the insurances that you've got to protect those assets within those different entities, and make sure that there's enough coverage for that. And obviously those documents are also well written and the beneficiaries are declared so that that can be executed on its own right. Correct?
That's spot on, and I think the advice we give or our clients that are going to enter into business ventures or property investment is one, get your structure right from the start, and make sure that the beneficiaries who's going to benefit from your structure is who you intended to be, through a family trust and so on, and have your will and have your estate planning happening from now. I think
So
that's
do you,
how people give their family the best chance of actually, surviving or making sure that their assets go to the loved ones. Really, that's the aim of this exercise.
yeah, absolutely. And I think it becomes quite critical, especially when you become incapacitated or for any reason that you're not able to do this for whatever reason. Because I mean, nowadays life has become so fragile with so many events happening, and you don't want to wait for that to happen before you can
Yeah,
take action.
and
It's
and,
just
and
like,
that's sorry to cut you off. I'm apologize, but I just wanted to also mention one thing quickly before we finish. Is we haven't touched on power of attorneys, which is,
yeah.
I believe, go hand in hand with wills, and we recommend people making them. So I guess we can discuss this in further details at a later time. But power of attorneys is it's a very, very important tool to cover that point that you've just raised, about not being able to take decisions as well while you're alive.
So maybe I think that's good. We can probably talk about 5 minutes on that just quickly. So,
Mhm.
what is the difference in power of attorney versus actually wills that are already there,
Okay.
whilst alive or whilst or if someone dies? Well, that one is that scenario, and second is if you're still alive, then what's the difference between the two? How does that come into effect?
So we recommend and we explain what a power of attorney is to whoever's making a will. So in a nutshell, power of attorneys could be divided into probably two or three categories. So we're talking mainly about a general power of attorney that could be for a certain period of time. Or if you're, for example, overseas, you can say, while I'm traveling, this person has general power of attorney. They can deal with my affairs. They can sign on my behalf. There's enduring power of attorney, which basically gives the person the right to make financial, medical decisions on your behalf if you're unable to make such decisions. And uh, look, a lot of the time we would have a couple that would come in and do the will, and at the same time they'll do the power of attorney. Um, the difference is basically the wills will deal with your estate after your passing. Power of attorney deals with decisions that you can't make for one reason or the other while you're alive. Really, that's a very simple way to put it. But I think that is probably the main difference.
Yeah, sure. So is that a separate document, like power of attorney, to give
It
someone
is
the
a
rights?
separate document. It is a separate document.
Yeah.
It doesn't. We keep them in the same register. We keep them in the same. So it's parallel to the will. They kept together, but it's a totally. You can decide to execute and have a power of attorney without a will, and vice versa.
Okay, so they're quite independent documents, but the effectiveness is getting incapacitated, or whether you are going to be absent at a point in time and you want someone to take control, versus saying once you die, then wills come into effect, essentially. Is that right? In summary?
Correct. That's yes. Correct.
Awesome. Awesome. Thank you so much, Amir. And that was so valuable. And I cannot stop thinking of more questions right now, because then I'm also quite conscious of your time. So I'm
Yeah.
sure we can be for the next 4 to 5 hours and keep going on it. But I think at basics and fundamentals of the importance of wills and importance of power of attorney is quite well discussed. And most importantly, I think you need a profession by your side who can help you, guide you, prepare this the right way, and at the same time be there for you when you are not there or you need that person the most, so that when you are not in control, someone else can do that on your behalf. Am I right?
Yes, you spot on again. Well done. And I think that's yeah. If I might add to it, just I think everyone's most important asset in life is their family, and that's why we always say give them the best chance, and don't take this topic lightly. It is a stigma in a lot of cultures. People don't like talking about death. They want to avoid this topic, but it's part of life. Yeah, yeah. So I think we need to deal with it. We need to deal with it.
Yeah, and of course we can help anyone around Australia to help them with this, right? They don't have to be
Yes,
in
100%. So obviously each state has its own regulations and all wills act, but
Yes.
we like I said, we practice. We're a national firm. We practice all around Australia. We've got offices in interstate, so that we are able to provide this service. And if it's out of our capacity, we will then make a recommendation on who they should use.
Right. Awesome. Look, thank you so much for coming on board, Amir. And I've taken too much of your time as a lawyer, but I completely appreciate you sharing your knowledge and experience with people. So those who are listening to this and are serious about actually taking action, please do so. Reach out to Amir. He's such a welcoming person and will help you, guide you through this process. And if you don't know his details, or if you like to reach out to us, we can help as well. But this is an important, critical topic that I think before you go back to bed tonight, you should be thinking hard on this and actually put this in your plan and on priority to get someone talking through this. You talk with your partner and go out there and get a document, because this can be a lifesaver for you, with especially when you're working so hard to create this lifestyle and wealth for you. You really want that to be managed after you go. So thank you so much, Amir, for coming on
Thank
board.
you. Thank you again for having me. It's been a pleasure, and look forward to hopefully doing this again in the future. Thank you.
Thank you so much, Amir. Thank you. Cheers. Take care.
Thank you. Bye.
Bye.